This is Emily Maynard, and I'm the project manager for the California Community College's Real Estate Education Center. I'm so glad that you're all joining us for our first webinar. Ed Estes is presenting, and he is a faculty member at Mount SAC, and he's going to be sharing a little bit about legal updates, including the new standard purchase agreement that's coming down the line. And if you have questions, you can open the question Q&A, or you can add some thoughts in the chat, and we'll do our best to sort of keep this moving as well as answer your questions. So I'm going to turn it over to Ed, and yeah, if you have anything that you need, I will do my best if you can just put it in the Q&A section or in the chat.
All right, so Emily's gonna pull up the first screen. We had a little technical difficulties on my end. So if she would be so kind as she's gonna actually run the PowerPoint, and I'm going to talk about the slides as they come through. All right, well, there we have my title page, there we have my name and my college. So what I'd like to do first are talk about some new cases that have come down in the last year or so. And I think you'll find them enlightening, and a couple of them are actually kind of entertaining. The first one there, the Spector versus Zagirius. I'm not very good on my case name pronunciations. We had a situation here where Spector sued Zagirius. I don't recall how it was going. I think it was the defendant that wasn't going very well in the litigation. And after about 2 years, they decided they were going to go back to the contract. And lo and behold, in the contract, there was an arbitration clause. So I think I just misspelled arbitration there too. So that's bad on my part. But anyway, court held that after 2 years, the defendants had in fact waived their arbitration rights. So that's important to note, that if you do have a contractual dispute and you have an arbitration clause that you want to enforce, you got to go with arbitration in the beginning. If you go into court and start litigation, you probably will not be able to go back and arbitrate the case. The next item, or next case, is the DeLisi versus Lamb. In this situation, and I believe this was a San Francisco case, the landlord decided to evict the tenant and put one of their family members in. Now, we will be talking about the statewide rent control law in a little bit. And that also has a provision that a landlord may evict a tenant without cause if they want to put in a family member. Well, in this case, it doesn't appear that a family member actually moved in, when in fact they newspapered up the windows. There was a report that they had left the light on in the apartment, but it never went off, and no one was ever seen entering or exiting the apartment. And the court held that this was not, in fact, a move-in of a family member. If you're going to evict a tenant and move a family member in, it has to be done in good faith. The next case, the Halley versus Allen. In this case, and I believe another San Francisco case, a real estate agent went up to the tenant and asked the tenant if a particular parking space belonged to that tenant. And the tenant was elderly and said something to the effect that no, that was not her parking place, when in fact that parking place had been assigned to that particular apartment unit. Whereupon the landlord then allocated that parking space to a different tenant and presumably charged that different tenant additional rent. The court here said here that no, you can't take a tenant's response to a questionnaire and have that modify the terms of a lease or rental agreement. The last case on this particular slide is one of my favorite cases. This is the Gary Gill Martin versus OBE Insurance Corporation. Gary Gill Martin was an independent real estate broker, and he did not have errors and omissions insurance. Well, he was involved in a real estate transaction and was actually a dual agent. So he represented both the buyer and seller himself. Well, after close of escrow, I guess there were some problems, potentially some disclosure issues. So the buyer decided to sue Gary Gill Martin as well as the seller. Well, Gary Gill Martin, of course, didn't have errors and omissions insurance, so he figured that this would be a good time to get an E&O policy, which he did. Well, lo and behold, after he got the policy, the seller then countersued against Gary Gilmartin, and Gary Gilmartin then offered or tendered up the defense of the second lawsuit by the seller to the insurance company. And the insurance company said, no, this is all part of one action. You did not have your E&O policy in place when the buyer first sued, so we're not going to cover you with a defense against the lawsuit by the seller. It went up on appeal, and the Court of Appeals agreed. So the bottom line here, and what we take from this is, make sure you have E&O insurance, make sure it's current. Don't try to get E&O insurance after a claim arises. All right, Emily, if we don't have any questions, why don't we jump to the next slide? All right, so the top case there, the Chun versus Del Cid, also found in many rent control ordinances, they exclude single-family dwellings. Well, in this case, the Chun versus Del Cid case, there was a single-family dwelling. However, I believe it had 9 bedrooms, 2 bathrooms, and 4 separate families living in a house. And the owner of the property said, you know, this is a single-family dwelling. I'm exempt from rent control. And the Court of Appeals said, no, what you are a rooming house. This is effectively an apartment, and you are covered by rent control. So if you do want to claim the exception or the exemption of a single-family residence, it does need to be occupied by a single group or family. And we're not going to get into a discussion here what constitutes a family, but definitely a living unit where they're all together, related in some fashion by either relationship, marriage, or blood. Our next case down is the Eisen versus Tanavarian. Here, CCNRs prohibited new construction from blocking views, but it didn't mention anything about a remodel. So the owner of this house decided to do some remodeling, and their remodeling, in fact, impinged on a view of a neighbor. Now, we probably should do some clarification here. We're not talking about a condominium complex or a planned unit development. These were single-family detached houses, I believe, but they were within a homeowners association. So as many of us know, many new developments will be done within a planned community, and they will have CCNRs that cover. So the court ruled the CCNR provision very strictly. It covers new construction, but does not cover a remodel. The last case here on this page is the Sands versus Walnut Gardens Condominium Association. In this case, the homeowner had some leakage, either through a window or a roof. I'm not sure, the case wasn't sure what it was about, but there was a leak into the unit, and the homeowner association was responsible. The property owner decided they were not getting the service that they wanted from the homeowner association, so they decided to sue, and they wanted to sue under a tort action rather than a contract action. Now, if you don't teach legal aspects of real estate, maybe I could make a little digression here. In a tort action, you're allowed to claim speculative damages. Somebody is injured, they go into court under a tort action, they're claiming pain and suffering. They can't really prove that they're actually in pain, but the jury can speculate that they are in fact in pain and can award damages. So that's allowed in a tort action. Not allowed in a contract action. In a contract action, you actually have to show actual damages. And that's one of the reasons we have a liquidated damages clause in the real estate purchase agreement, is because in order for a seller to sue the buyer, they would have to show actual damages. In other words, they would have to show that there was another buyer out there that was not able to purchase the property because buyer 1 bought the property and then buyer 1 defaulted, and buyer 2 was nowhere to be found after that. Very difficult to prove actual damages, but that is what you need to prove in a contract action. In a tort action, you may only need to prove speculative damages. Well, in the Sands case, the court ruled that if you're going to sue an owner association, you need to sue under contract law. You can't sue under tort law. Emily, if we don't have any questions now, I'd like to go to the last page of cases. The first one case here, the Fabian versus Renovate America. This is kind of a concerning case because it ruled against DocuSign being an electronic signature. Now, before I get too much into this, let's talk about what the case was about. This was a case where a solar company induced a homeowner to sign up for a solar system or solar panels on their roof. And in doing that contract, they used DocuSign. So I think the court may have been a little prejudiced here because of all the bad publicity and press that are out there against these solar companies that induce homeowners to sign up for these solar systems. And oftentimes these homeowners don't exactly know what they're signing into. But let's just kind of put that on the side and let's talk about the facts of the case. In the facts of the case, the defendant, the solar company, Renovate America, did not adequately do their prove up to explain why a DocuSign signature is a valid signature. So what we take from this case, if somebody is sued over whether or not a DocuSign signature is in fact a true electronic signature, you're going to have to prove up the mechanics of DocuSign. So my recommendation would be to contact DocuSign, have them provide that information that you could then introduce into court, showing how DocuSign works. Now, I think most of my audience here understands DocuSign, but just to refresh, a real estate agent who's going to use DocuSign sends an email over to their buyer or seller. There's a link in that email that they can then click on. They go into DocuSign, they put in a username, they put in a password. Now they have access into DocuSign. And it is only them, armed with their username and their password, that allows them to go in to the site and then initial and sign documents. And they can then also customize what their initial is going to look like, what their signature is going to look like. It's important to note that their initials in DocuSign, that their signature in DocuSign is not actually the electronic signature. The electronic signature is the username and the password that is controlled by that particular person, and that is how their consent or their signature is authenticated. What is a signature? How do we define a signature? A signature has to have two qualities. First of all, it needs to be unique. In other words, nobody else can forge it, or essentially nobody else can forge it. Secondly, it needs to be attributed to that person. So, which is why most of us, for our signature, use our name, because our name is attributed to us. And because our signatures, in my case, is so hilariously sloppy and messy and convoluted, no one else could possibly duplicate it. So everybody knows it is my signature. If I were to send one of you an email, and at the bottom of my email, I were to have my name, college, address, that would constitute an electronic signature because it is coming from my IP address and it has my name. Nobody else can replicate that unless they were to steal my login information or unless I was to share my login information, which I would never do. And this is one of the reasons that Mount San Antonio College, and I suspect at your colleges as well, you require your students to use their college email in all of their communications with you, because that is how you verify it is actually them. You don't want to use their Gmail or their Hotmail address because other members of their family, spouses, may also use that email address and you don't know who it is. So again, in this case, the DocuSign case, you do need to prove up if you're going to be using an electronic signature. I think I've beaten this dead horse again, enough, but if we have questions on electronic signatures, Emily will relay those to me. Let's cover the last case first, the Ryan versus Real Estate of the Pacific. In this case, Mr. Ryan was hosting an open house, and a neighbor came over and told him that the neighbor was going to be doing some construction and building a wall or building along the property line. and just wanted the real estate agent to know about it. Well, the real estate agent failed to convey that information to the buyer, and the buyer, I'm sorry, Ryan is the buyer, not the real estate agent. I apologize for that. And then Ryan then sues, and arguing that he was never explained this by the real estate company or the real estate agent at Real Estate of the Pacific. And the court held that yes, if a neighbor tells a real estate agent something about the property or the neighborhood, then the real estate agent has an obligation to convey that to potential buyers. Now, this can be a little dicey because this information is arguably hearsay. So my recommendation, if a real estate agent finds themselves in this situation, you would say something to the effect that the neighbor across the street, identify the neighbor, told me this. I'm not sure if this is true or not, but I thought I should share this information with you. And you probably should document that as well in the AVID, Agent's Visual Inspection Disclosure. Emily, do we have any questions so far?
Nope, no questions. No questions at this time.
Well, that's good. That means I'm doing my job, or everybody has hung up, or somebody is sleeping. Let's go ahead and go to the next slide. And we have some recently filed cases. They're actually joint cases. They're all dealing with the same issue. And what they're trying to do is require that the multiple listing service will publicly display the amount of commission that's going to be shared to the cooperating agent in the public comments in the MLS, so that when Zillow and these other third-party sites pick up information from the MLS, the viewer of the MLS can see how much commission the agent who will be representing them is receiving from the agent who has taken the listing. Now, I think the reason behind this is we do have several real estate companies, I won't mention them on the air here, but we do have several real estate companies who follow a business model where they reach out to potential buyers, let the potential buyers or suggest to the potential buyers that they go out and look at properties which this real estate company provides to them. They actually visit the properties with the listing agents. And then when they're ready to purchase the property, they go back to this broker. The broker actually writes the offer and then will rebate a portion of the commission back to the buyer. So hypothetically, if there's a 3% commission being offered to the broker who is representing the buyer, this particular company might rebate 2% back to the buyer, keeping 1% to themselves, or maybe rebate 1% and keeping 2%. We don't know where this is going, but it could have a significant impact on how real estate is marketed as we know it today. Emily, let's go on to the next slide. And we now have a couple of new DRE regulations. I think most of you are familiar with the first one, where the disclosure of the license identification number has to be on solicitation materials. The Department of Real Estate has clarified this a little bit. It needs to be on all points of first contact, or all points of contact for that matter, not just first contact, but all points of contact. So that would be signs, emails, letters, flyers, business cards, website. I mean, anything a buyer could possibly see or a seller could possibly see. If you got your name on it, you have to have your license number on it. One exception, directional signs for open houses. Do not have to have your license number on that. But the for sale sign or the open house sign on the property, you need to have your DRE license number. I might want to make a humorous point here. About a year ago, I thought it might be cute to delete one of the zeros from my license number. I will have one of those old license numbers where my license number begins with 2 zeros, not 1 zero, and taking the position that a zero to the left of a number doesn't have any value, so I could just delete it. Somebody shared that with one of the deputy commissioners at the DRE. I actually got an LOL email from the deputy commissioner. She did think it was pretty funny, but she said, Ed, please add the other 0 to your license number. So for those of you old timers like myself who have a license number that begins with 2 zeros or even 1 0, you need to put the zeros on there so they know truly how old we really are. The last regulation on this page, 2915, this came about last year, where if you have disciplinary action listed on the public site of the Department of Real Estate's website, you may by petition have that removed. The conviction must be at least 10 years old. It is discretionary by the real estate commissioner. He or she, as you know, we don't have a real estate commissioner right now, or at least last time we checked, we didn't have a real estate commissioner, but we do have an acting real estate commissioner. And there is a non-refundable fee of $1,275. So you pay that fee. You have no assurance or guarantee that it will be granted. You don't get that fee back if the commissioner rules against you. Again, the conviction has to be over 10 years old. And more likely than not, it needs to involve something that doesn't directly reflect to moral turpitude. I actually have a former student, or had a student, who had his sales license revoked due to fraud and forgery. He had an interesting plan. When his sales license got revoked, he took his broker level classes at Mount SAC and then decided to apply for his broker's license. The DRE was not amused. They did not grant his broker's license. And I think there is little or no chance that he will ever have that discipline removed, because as we all know, there's probably nothing worse for a conviction against a real estate agent than fraud or forgery. That really speaks to the heart of a real estate licensee's integrity. You cannot have real estate licensees out there who commit fraud or embezzlement, or excuse me, fraud or forgery. Emily, if we don't have any questions, let's go to the next slide. So now we're going to start the new laws, and we're going to kick it off with the new statewide rent control. So let me get through these 2 slides. I feel the questions coming out there, unless you're more knowledgeable than I am. I'm still learning things about this new law. 1482. First of all, there is a cap on how much you can increase your rent, and that is 5% plus local CPI, but it cannot increase more than 10% a year. So 5% is the cap, plus whatever local CPI, consumer price index. Cannot exceed more than 10%. Now, if you choose to raise the rent this year, let's say 7%, and next January 2021, you decide to raise the rent again, they will count this year's rent and next January's rent, and it cannot exceed 12% because it was within 12 months of each other. So we both have the calendar cap, but then we also have this 12-month cap. Basically, the legislature does not want you raising the rent more frequently than every 12 months. So they got you on the calendar year and they got you on the 12 months. So just an FYI on that. Next, evictions must be for just cause. In other words, if you're going to evict a tenant, you have to have a reason for it, such as breach of the lease, criminal activity, failure to pay rent. Now, this will kick in once the tenant has been a resident of the premises for 12 months. So essentially, you have an 11-month, 29 or 30-day honeymoon to figure out whether the landlord really gets along with this tenant. So during that first 12 months of residency, the landlord can evict the tenant for no reason whatsoever. Just simply give a 30-day notice and the tenant is gone. But after the tenant has been there for 12 months, then the law takes into effect. The thinking here is, if this is a bad tenant, this gives the landlord 11 and a half months or whatever to make that determination. Could a landlord enact a policy that they will evict all of their tenants or only make leases for an 11 and a half months? I guess they could, but the thinking is after 11 months, you're going to know whether you got a good tenant or a poor tenant. And if you've got a good tenant, it really doesn't make sense to get rid of them and then go out into the rental pool and bring back a tenant that you don't know. You know, the thinking is the devil you know is probably better than the devil you don't. So that's the thinking, I think, or I believe, regarding this. I'm going to get through this slide before I start taking questions. Now, we've taken care of the at fault. Let's go down to the no fault. You need to have justification if you want to get rid of a tenant who hasn't breached the lease. So this justification is a family member, significant remodeling, withdrawing the unit from the rental market, or government order. So single family residency, you have a family member moving in. How close that family member has to be, we don't know. Could it be your third cousin 5 times removed? I don't know. Certainly, direct relationship, brother, sister, son, daughter, grandson, granddaughter, grandparent, that probably fits. When we start going out to cousins and uncles, aunts, we don't know yet. We're going to have to see what happens with the courts. Significant remodeling. At the very least, you're going to need a permit. My feeling is the remodeling, when it is being done, would impact habitability. In other words, during the remodeling, the premises really aren't fit for occupancy. You're going to be shutting off utilities like power, gas, electricity, sewer, things of this nature. So the premises is not habitable. That would certainly qualify. Withdrawal from the rental market. You are taking the property off the market. You are going to sell the property to a prospective homeowner. Government order. Condemnation, eminent domain would certainly qualify. If you are taking the tenant out via no fault, you must provide relocation assistance, and that is the equivalent of 1 month's rent. You can either forego the last month's rent, or if you're going to pay the rent to cash to the tenant, it needs to be done 15 days prior to the expiration of the tenancy. All right, so Emily, we do have some questions. If it's on this slide, I'm going to go ahead and take it, but we need to go through the exceptions, which is on the next slide. So there was a question, I think, that came in. Could you either flash that up or share it with me?
Sure. The question is, what about the 90-day notice if rent increases more than 10%? That would seem to imply we could increase greater than 10% so long as we give 90-day notice. Is that correct?
Correct. That is my understanding. If you want to raise that rent more than 10% in a 12-month period, you've got to give a 90-day notice. But that 90-day notice would have to be, in my example, in 2021. So if you gave that 90-day notice in January, you couldn't raise that rent until April because you would have to go those 90 days, assuming we're working on a 30-day month. Does that make sense? Hopefully out there. And essentially, they're trying to put a roadblock up here to keep you from raising that rent more than 10% in a 12-month period, hence the 90-day notice. Do we have any other questions?
No other questions for now.
Great. Let's go to the next slide and we'll get into some of the exemptions. Okay, so the big exemption out there, single family home, or condo, if the tenant has received a notice of exemption and the owner is not a real estate investment trust or a corporation. So we all know what a single family dwelling is, and we are renting this single family dwelling to a single family unit. So it is spouses and children, it is parent and child, but they are living in a cohesive unit. It's not a rooming house, as I earlier talked about. You also have to have provided, or the landlord also has to have provided, this notice of exemption. And later in this slideshow, I will show you an example of CAR's notice of exemption. But you have to give that to the tenant so the tenant understands that this particular property is not under the statewide rent control. Finally, the owner cannot be a REIT or a corporation. It can be in a living trust. It can be in a LLC, as long as none of the members of the LLC are a corporation. All right, so we got to make sure that clear. Also, properties built in the last 15 years are exempted. So this would include apartment buildings. This was put in to stop opposition from the construction industry. Now, this is a rolling time frame. So if I own a 15-year-old apartment building today, I'm not covered by the statewide rent control. However, next year, my apartment building will be 16 years old, so I will be covered. Last, owner-occupied duplexes. The thinking here is if you are living in one of the duplexes and you rent out the other side, and you and your neighbor are not getting along, you can kick them out. Okay, so it doesn't apply there. But this exemption is for duplexes. It's not for a triplex or a fourplex. If you have a duplex and you add an additional dwelling unit, an ADU, you turn yourself into a triplex, and you're not going to get this exemption, in my opinion. All right, so let's go to AB5. AB5 is pretty straightforward for all of us. AB5, of course, is that independent contractor qualification. It is currently going to be challenged on the ballot box by Uber because it's going to blow a hole in their business plan. But the nice thing for real estate licensees, it's created an exemption for us. First, if you hold a real estate license. Second, your compensation is based on commissions. And third, you have a written independent contractor agreement with your broker, then you are exempted and you can remain an independent contractor. But here's where we're going to see some problems. Unlicensed assistants. Unlicensed assistants, part of teams or part of successful agents, they need to get a real estate license if they're going to be compensated as independent contractors. Otherwise, they need to be treated as employees, which means they need to be salaried. They need to have normal working hours, and they can't be compensated by a bonus system. So this is actually an opportunity for all of us who teach real estate. I am going out there on LinkedIn and other social media, letting teams know that, hey, if you've got an unlicensed assistant and you're treating them as an independent contractor, as of last January 1st, you're in violation of the law. You need to get them a real estate license. You need to enroll in Mount SAC. They need to take our 3 classes and get themselves licensed. Otherwise, you're going to be in trouble with the Department of Labor. Emily, if we don't have any questions, let's go ahead and go to the next slide. All right, Senate Bill 778 requires sexual harassment training, 2 hours for all companies with 5 or more employees. An employee would be managers and W-2 employees for 2021. This also will extend to abusive behavior. So you need to give sexual harassment training and training against abusive behavior to all of your W-2 employees. Does not extend to independent contractors. AB 670, homeowner associations can no longer unreasonably restrict accessory dwelling units. So again, this doesn't necessarily pertain to condominiums, I wouldn't think, but for those single family detached homes in an HOA, If they want to convert their garage into a dwelling unit, they may be very well able to do that. Of course, this creates a land use issue because where are they going to haul park their cars? Presumably on the street. That's going to be another problem that cities and the states are going to have to deal with. SB 652. Landlords and HOAs cannot prohibit religious items on an entry door. I don't think that's too big of a problem with HOAs. Might be, but it could be a problem with apartment buildings. So just a heads up for landlords. If a resident wants to put religious a cross or what is a mausa, the little scroll box that people of the Jewish faith often have on their door, they're allowed to do that. Senate Bill, let's see, 1343, you cannot refuse to rent to or refuse to sell to a daycare provider. So it sounds like daycare providers may now be entering into the area of a protected class. More to be seen what happens with the legislature at the next term. Before we go to the next slide, Emily, I think we have a question out there.
Yes, the question is, regarding sexual harassment training, if I have a team and train the paid staff over 5, do I also have to train the agents who are paid by the broker of record?
You would not have to train the agents no matter how they're paid because they are not W-2 employees. So independent contractors are not covered by 778, only salaried employees. So those W-2 employees, they are covered. Independent contractors, no matter how they get paid, at this point, they are not covered by sexual harassment training. I think there's still a philosophy out there that because independent contractors have a certain amount of freedom, they're not as vulnerable as, say, a W-2 employee. Anything else, Emily?
That looks like it's it for now.
Okay, great. Let's go to the next slide. All right, so Senate Bill 234, large family daycare homes. So this would be homes taking in as many as 14 children. They are now treated as a residential use. Therefore, they are not considered to be a material fact for disclosure purposes. They are simply a residential use. And as far as we're concerned, it's just another neighbor down the street. If, however, the daycare facility does have an adverse impact on the value of a property that you have listed, for example, traffic issues or noise, now that may be a material fact, but merely the existence of a daycare home with 14 children or less, that in itself does not warrant a disclosure. It's just simply a residential use. AB 1018, when home inspectors go out to a property, they may make a comment as to whether or not the property is or is not worth what the property is being sold for. They can't do that anymore. They cannot give opinions of value. And appraisers, when they go out and appraise a home, they are not to be making a home inspection. So buyers should not rely on the appraiser as a home inspection. Now we know, particularly with FHA and VA, they will make, if we want to call it recommendations or requirements, coming from the lender, it's certainly a requirement. I think from the appraiser, it may be a recommendation, but they certainly make points that certain things should be or need to be repaired because of requirements of FHA and VA. That's one category, but the bottom line of the statute, they don't want people to view an appraisal as a home inspection. Emily, I think I see a question. Why don't we take that question right now?
Sure. Regarding appraisers, don't FHA and VA appraisers do some level of inspection?
Well, you could argue that an appraisal is an inspection of the house because they do go through the property. Typically, they don't operate systems. They don't test things. They typically don't look at things like plumbing I had an appraisal done on our property once, and there had been a plumbing leak in the ceiling, and there was actually a hole in the ceiling because they were in the middle of repairing it, and the appraiser never even saw it, didn't even look at the ceiling. Gives you some comment on what you think of what I think of appraisers these days. But yes, appraisers do make comments, but these are not to be viewed as home inspections. So I think what the legislature is trying to do is make a clarification. Appraisers need to focus on determining the value of the property, and home inspectors are to focus on testing systems and coming up with an opinion on what the condition of the property is. There's always going to be an overlap here, but I think the legislature is trying to draw a line. AB 38, disclosure and point of sale compliance regarding defensible space. So in those areas that are prone to fire, so we've got the state responsibility areas, and we have the wildland fire areas that are noted in the Natural Hazard Disclosure or NHD report. It's anticipated that local governments will start identifying those properties, going out and requiring property owners to create defensible space and require property owners to have fire retardant landscaping. This is a item in motion right now. You're going to start reading more and more about it. The Los Angeles Times did have an article about it about a week or so ago. So this is going to be coming out. So we will see additional disclosures as local governments start making these identifications. Presumably, it's going to show up in the NHD report, but I don't know. Again, it's a work in progress. We're going to see what happens. Just a heads up, it's coming our way. You'll know more about it probably 6 or 18 months from now. And last item, SB 18, 90-day notice to give to a periodic tenant if the property has been foreclosed upon. So we all know that if the tenant has been in the property for less than, 30 days, less than a year, you need to give a 30-day notice. If the tenant has been in the property for over a year, you need to give a 60-day notice, both on a periodic or month-to-month tenancy. If, however, the periodic tenant is in the property and the property was foreclosed upon, the beneficiary who forecloses on the property takes the property back. They must give a 90-day notice. Emily, if we don't have any more questions, let's go to the next slide. So AB 827, if your residential or commercial property is generating more than 4 cubic yards of waste, you need to have recycling bins for them. Not that they'd actually properly use them, but you're required to have them. SB 329, source of income, now a protected class. And specifically, we're talking about Section 8 tenants. So landlords may not make a blanket refusal to rent to Section 8 tenants. Now, does a landlord have to rent to a Section 8 tenant? Well, it depends. The landlords can certainly follow their qualification guidelines. They can certainly look at the credit history of the tenant. They can certainly look at the past rental history of the tenant. They can certainly go on references. If the landlord has an income requirement, let's say hypothetically 3 times or 2.5 times monthly rent, but Section 8 is paying 1/3 of the rent, then the landlord could only require 2 times monthly rent or something like that. So they would have to adjust their income qualifications based on the percentages that Section 8 is supplementing the rent. I don't know if a landlord could say, I require this particular rental agreement, and if you want to sign this particular rental agreement under Section 8, I will rent to you, knowing that Section 8 will not do that because they have their own rental agreement. I don't know exactly how that's going to play out. All we can say at this point, landlords do not publish anything that says no Section 8s. If somebody calls you and says, do you take Section 8s? You would have to say, yes, if they qualify, please come in and fill out a rental application and let's see where you are. So that's where we are on this statute. SB 222, military service members and veterans are now a protected class. So we have race, we have color, we have familial status, we have disability, we have citizenship, we have foreign language spoken. I could go on and on. Add to that military service members and veterans. They are all now considered a protected class. You cannot discriminate them on the basis of their military service. And connected to that, we have SB 644, security deposits for military service members, both active, reserves, also National Guard. For an unfurnished unit, it is no longer 2 months rent, it is 1 month's rent. For a furnished unit, it is no longer 3 months rent or the equivalent of 3 months rent, it is now the equivalent of 2 months rent. So it's been decreased by 1 month. Before we go to the next slide, Emily, I think we have a question out there.
Yes, the question is it up to the service member to let the landlord know that they are reserves, or does the landlord have a duty to ask up front?
You know, the statute is not clear on that. I would say that the service member would either have to tell or the landlord would have imputed knowledge by doing the credit check. So if they're an active service member, you would see that on their employment. So that wouldn't be a problem. The veteran, if they're wearing a baseball cap that says Vietnam veteran, I would think that would be a red flag. If they're wearing military related clothing, that might be a red flag that would warrant an inquiry. But I don't think you would ask, because again, when I deal with protected classes, I try to deal with them all the same. You wouldn't walk up to somebody and say, hey, do you have a disability? Or hey, are you of color? Or hey, do you only speak a foreign language? I think you would have to learn through the application process or have it disclosed to you. But I don't think I would ask them, just like I wouldn't ask somebody if they have a disability. Do we have another question?
Yes, another follow-up question with that is, does the security deposit limit apply to existing tenants? Would it require refunds of the difference for existing tenants?
My feeling here is yes, it would be retroactive. So if you have a service member, my recommendation would be to refund it, so you don't have an excess amount. However, if that service member has been in your unit for a few years, your rents have probably gone up. All landlords do things differently, but I know it is not unusual for a landlord, if they have a good tenant, to leave the security deposit in its original amount. So you would calculate the equivalent of 1 month's rent or 2 months' rent based on current rent. So it's quite possible that if you collected, let's say, 2 months' rent on an unfurnished apartment 5 years ago, you might not have to refund. You might only have to refund a half a month's rent or a quarter month's rent, because over the last 5 years, given what's happened with rents, you might be up to the equivalent of 1 month's rent. So you probably want to keep that in mind. But yes, if you have more than 1 month's rent or 2 months' rent based on furnished or unfurnished, my recommendation would be to refund. Anything else, Emily? No, so we go to the next slide. So Civil Code 1798.100, the California Consumer Privacy Act. So as of January 1st, Citibank, Wells Fargo, Ralph's, Albertsons, all those people that collect your information because you want to get cheaper Twinkies, or you want to get a special something from your credit card company or whatever. Anyway, now under California law, they must allow you to opt out if you want to opt out, and you have the right to do so. Does that apply to the multiple listing service? That's the concern that a lot of realtors have right now. And the feeling is it doesn't, at least in most MLSs. I believe Seattle has a private MLS, so it might be for profit. This statute only applies to profit entities. It doesn't apply to nonprofit at the present time. Of course, the problem is, even though the MLS is nonprofit, entities that harvest that information, like Zillow, are for profit. So does it extend there? And the bottom line is we don't know. So playing it safe, CAR has created a new form, which I will get to later in the slide deck, to deal with that. So there are some MLS concerns. So you do have a new disclosure form that I will talk about in a few more slides that deal with the California Consumer Privacy Act. Prop 65, safe drinking and water toxic enforcement. We've got some new rules that have been introduced specifically for underground parking, because cars emit exhaust and that can be a carcinogen, and smoking areas. A number of businesses have designated smoking areas. A number of apartment owners don't allow smoking in their apartments, but they do provide smoking areas in the common area. Expect to see signs identifying the Prop 65. So when you go to the gas station, you see that Prop 65 notice there next to the pump. Expect to see more signs. Landlords should probably be putting up those Prop 65 signs in their designated smoking areas. If you have underground parking, or you're managing a property with underground parking, you should probably look into putting those Prop 65 signs in your underground parking spots. Emily, if you don't have any questions, let's move on. So some other legal issues and concerns. Model MLS Rule 12.11. Now, depending on which MLS you belong to, I know a number of licensees out there belong to CRMLS. It's one of the largest, if not the largest, MLS in the state. You are not allowed to mine expired listings for prospecting purposes. You cannot go into the MLS, look up expireds, and then use that information to contact expireds under the MLS rules. I know a lot of agents do it. And when I announce this to a group of real estate licensees, they say, well, how else am I supposed to do it? And I respond, I don't know, but you're not supposed to get it from the MLS. So just an FYI, there is an MLS rule that prohibits it in the model rules, and that has probably been adopted by most of your local MLSs. So I would refer to your local MLS. CRMLS certainly has it. So if you belong to a different MLS, you might want to look that up. Photographic image license. So if you're using a professional photographer for your listings, you should probably have some sort of a release, and CAR does have a form for that, so that the photographer does not retain rights to that photo. You want to own the rights to that photo. You paid for that photographer to come out. You paid for those photos. You want to own them. So make sure you get that license. And then virtual staging and enhanced images. There are concerns about misrepresenting the property, either for sale or for lease. So all of you have seen this software where you can look at a photo in a kitchen, and you can change the color of the cabinets or the ceiling, the walls. Well, you can also make that brown lawn look green. And you can put a pool in the backyard or a gazebo, or you can do all kinds of things. And that is misrepresenting the property. So again, be careful with virtual staging and enhanced images. Property that doesn't have furniture and you use virtual staging and you put furniture in there, you need to put a disclosure in there that the property is vacant, This is virtual staging. This furniture doesn't exist. It's just in there to give a perspective of what the room would look like. And again, that perspective needs to be accurate. Don't virtual stage with miniature furniture to make the room look bigger. Emily, if we don't have any questions, let's go to the next slide. Okay, so we've got some new forms. I have a bullet list there for you. Let's go to the next slide and we'll go through the forms one at a time. Next slide. There we go. The purchase agreement probate addendum. So the purchase agreement, we used to have a probate purchase agreement. CAR is moving away from that. The thinking is we're going to have one single family purchase agreement. I say single family purchase agreement. The RPA CA is for a single dwelling, house or condo. If you have multiple dwellings, even a duplex, you should be using the RIPA, Residential Income Purchase Agreement. If you read it, you'll understand why. It reads pretty much the same as the RPA-CA, but it does call for things like security deposits, a tenant estoppel certificate, things of that nature. Well, anyway, if you have a probate listing or a probate purchase, you would then attach this to the purchase agreement to outline the purchase procedures, particularly things like the overbid process and the Independent Administration of Estates Act. Emily, let's go to the next slide. Photo and video agreement and release. So this is kind of in tandem of what I was talking about earlier with the release from the photographer. Let's say you're out there or your photographer is out there and they're taking pictures of the property. Well, they happen to take a picture of the seller's dog. And does the seller have any rights to royalties because you took a picture of their dog, even if it was the back end, and you're now publishing it out there in flyers and such. So it's a good idea to have this signed by the sellers so that if you inadvertently get a picture of the dog, the child's artwork from their second grade class on the refrigerator, they're releasing that right to you. So you can certainly use the photos in your marketing of the property. Let's go to the next slide, Emily, if we don't have any questions. Oh, so our wildfire disaster advisory. This has been with us for about a year, maybe a little bit longer than that. If you have a property that has been identified in your NHD as being a wildfire risk or state responsibility area, I would recommend to use this disclosure to the buyer. Also, if you're in an area where you know that there is a fire risk, I'm in Southern California. Mount San Antonio College is named after Mount San Antonio Mountain, which is also known as Mount Baldy. So we do have the San Gabriel Mountains behind us. If I were taking a listing on a property that was up against the San Gabriel Mountains or in a mountain area like Big Bear or Lake Tahoe, this would be a good form to include because you do have the risk of fires there. Let's go to the next slide, Emily. The California Consumer Privacy Act Advisory, or the CCPA. For those of you who are old enough, it kind of reminds me of the initials of the old Soviet Union, right? This is the form that we would use to disclose to our sellers and buyers that information gained from the property is going into the MLS and that information is going to be distributed. So again, Consumer Privacy Act disclosure form, probably a good idea to include this, even though it technically should not apply, this law should not apply to the MLS. It is a good idea to have it just in case they change the law and we're suddenly covered. We just don't know. Let's go to the next slide. Here we have the rental cap and just cause eviction addendum. So as I mentioned earlier, as we were going through that state law regarding the statewide rental cap, this is the form that landlords need to give to their tenants of their single family dwellings, condos, houses, so that they will then be exempted from the statewide rent control. However, keep in mind that if you are in a jurisdiction with its own rent control law, that may apply. Also, if you are in an area that has its own rent control law, whichever rent control law is more strict, or whichever provision of a rent control law is more strict, that's what you're going to go under. So landlords get hit with the strictest law. And let's go to the next slide. Seller Vacant Land Advisory, SVLA. So this essentially is going to be viewed as a TDS for vacant land. So the Transfer Disclosure Statement, or TDS, is a state mandated form. It's required by statute unless the seller is exempt on single family dwellings, 1 to 4 units. There is no mandated form for vacant land. However, there's things that it probably would be a good idea for sellers of vacant property to make a disclosure, and this would be the appropriate way to make disclosures if you're selling vacant land. Let's go to the next slide, if we would. And we're done with the PowerPoint. But let's keep this slide up because I do want to make my contact information available to the viewers of this. I also want to caution everybody that even though I am a member of the bar, I'm not giving legal advice. This has just been an educational experience. A couple of musings, since we do have a couple more minutes on the new purchase agreement. The new RPACA is under draft right now. They are on draft 8. It is accessible from the CAR website. If you have difficulty accessing it from the CIR website, and I know that CIR website is not the easiest website to navigate through, if you want to send me an email, I'll be more than happy to send you the 8th draft of what it's looking like right now. If you are familiar with the SUM RPA, it is a single page form that in a grid fashion provides the important points of the purchase agreement. Essentially what CAR is doing is they are going to take this grid format, which will include the timeframes and other boxes to be checked, and put them on the first 3 pages. So the contract will introduce the name of the buyer. It will then give the agency disclosure, and then you will go into a grid format for the next 3 pages. And then following 13 pages, yes, the RPA is going to go to 16 pages at this point, will have the textual material of what all these boxes and timeframes relate to. The thinking, I guess, is agents are more concerned about the timeframes and which clause applies, so that will all be listed on the first 3 pages. The actual content and meaning of the contract will be in the later 13 pages. Now, the good news is probably 98% of the meaning of the contract has not changed. If you understand what the RPA does today, then you're going to understand what the RPA is going to do in the new revision. There's a couple of exceptions. Currently in the RPA, if you have an all cash offer, you have to show proof that you have the cash with the offer. Unless you check the box, then you have 3 days. In the current offer, you have 3 days to show your pre-qualification or pre-approval of the buyer, and that you have closing costs and down payment, unless you check the box and then you include it with the offer. In other words, the cash paragraph and the down payment and qualification paragraph are opposite, which makes no sense whatsoever. They are going to align those. That information now needs to be provided with the offer unless you check the box. then you have 3 days to provide that information. So that's probably the most major change in the new agreement. Again, it's not significant. Most agents don't know it even exists in the first place, but it is going to 16 pages. We should have the final version in late May or early June. It will not be accessible on zip forms until December. Between June and December, CAR is going to be providing classes. I will be providing classes to my local associations. Those of you who'd like to teach at your local associations, you may want to be providing classes as well. I find that providing classes is an excellent way to introduce myself and our real estate program to the real estate community, because I find that many of my students have come in because they have a friend or family member who's in the real estate business. Emily, that's about all I